Alright, welcome to my channel. My name is Jeff Fortin, and you're not going to see my face for very long, but first, thank you to the Dubay band who made that version of O Canada in a rock form. So yeah, thanks to them. And today, as you see behind me, we are working on Operation Freedom Canada, the creation of a de jure Canadian kingdom. For those who don't know, Canada is a constitutional monarchy. That's the form of our government. So therefore, it should be formed that way because that's the form of our government. Couple of disclaimer before I get started. I'm a Frenchie from Canada. And in my culture, we swear, so I will swear, right? So that's a disclaimer that you must all know. Secondly, what I'm about to present to you is for you to use. Of course, I'm gonna tell a story. It is not the story of me, it is the story of us. Even though especially the first portion of what I'm about to dive into, does not involve you personally. It's the story of us as Canadian, as from our past and history and everything that is Canada. What I'm about to say is based on fact. It is not my opinion. It is not my wishful thinking. It is not something I made up in my mom's basement. It is fact. It is all publicly accessible. It is all verifiable, historical, and you can check it out. It was done in French in Quebec, in the national state of Quebec, which is not the province of Quebec. And last disclaimer is I didn't want to have to do that. I am not happy that I had to do that. It does not make me feel good that I had to do that. I am sharing it with you because it's fact, because it's the truth. I was not happy when I discovered all of what I'm about to share with you. I am not happy to this day. I am not your savior. I will not save you. It will be up to you to take what I'm about to present to you and do your best with it. I don't have it with me just right before we started, but my main working document is the Constitution of Canada, and I want to make sure that it is very clear that it is the 1867 BNA Act version unmodified that my work is based on. For practicality, I've used the more modern version, the one that came after 1982. And I'll finish before I get started by saying this. We, as people, don't have Canada. It does not exist in reality. What we have is a very altered version of the original under a corporate form and nothing else. Government should be corporate, but it should not be private. It should be public. It belongs to us. They obey what we, the people, say and wish and want. They listen to us. They do not enslave us. So, let's get started. Operation Freedom Canada. This is a condensed version of what was done in French to pass it on you all of you that lives in Canada and elsewhere in the world that don't speak French. Enjoy. Yeah. It's not pretty. Oh, by the way, this is the presentation. I'm gonna share my screen. I'm gonna try to go down slide by slide. I may forget, so pardon me in advance. I'm gonna read this. I'm gonna try to, like I said, and I'm going to cut off my face, maybe. I will come back, at some point, put my face on. But yeah, you'll have plenty with my voice alone. And the reason why I'm reading is because I don't look like this, because the camera is way below. So yeah, this is why I want to cut my face. So let's do it. Here we go. So I must not forget to press on the button. Let's get ready. Hold on. Let me restack my stack. Alright, we're all stacked. Let's get into the software. Here we go. So, I will read from the slide. Some are picture. I will make comment on them. 2015 Grand Jury of the People of Canada and the De Jure Society. History in the making. Welcome to it. It is your story, as I said. Your host today, well, that is me. This presentation will be divided into 4 parts. The first part is a review of the 2015 Grand Jury of the People of Canada and other related information. The second part highlights some of the learning that surfaced during the Grand Jury of 2015. The third part will focus on exposing the division, and the fourth part will focus on the future that we wish to create, a public society, a de jure kingdom. Before I go any further, I would like to mention that this presentation is a co-presentation between me and Miss Maureen Weirs, which gladly helped me create this actual presentation. A portion of it originally, when we designed it, was for her to talk about. I am less familiar with this part than the part that I had to read about. So please pardon me if I lack a little bit of knowledge when we get to the said portion. So, a little background about yours truly. I am originally from the national state of Quebec, and notice that I don't use the wording province of Quebec. I am a Navy veteran. I received an honorable discharge for medical reason in 2008. I was the lead prosecutor in the Canada Grand Jury of the People in 2015. I do love to read, in particularly with emphasis on historical reference and legal review. I've read pretty much every legal document that is in existence in Canada today, with my focus being on the Constitution. I am not and will never be your leader. I didn't write this slide, so Maureen added a true patriot who love all beings and love country. Yes, I do love the country of Canada and the people that populates Canada, but I don't like what they've done of it. And when I say they, it's the private corporation and whoever else has changed what Canada is. Alright, let's get straight into it. So this is part 1, the 2015 Grand Jury of the People of Canada. Let's jump right into it. Part 1, Grand Jury, a brief history. What is a grand jury? A grand jury is a group of citizens empowered by law to conduct legal proceeding and investigate potential criminal conduct and determine whether criminal charge should be brought. A grand jury is separated from the court, which do not presides over its functioning. Grand juries were once common across Canada. Archives shows a grand jury process from Quebec City early as 1764, which was called the Quarter Session of the Peace, and the latest that we know of was in PEI in 1871. The grand jury celebrated its 800th birthday in 2015. The Magna Carta Libertatum was executed on June 15 of the year of grace 1215 or 1215. Canada abolished the grand jury in 1984, but, and here's the kicker, this was unlawful, illegal, and unconstitutional. The grand jury can be described as the shield and the sword of the people. A shield for the people from abusive indictment of the government, and a sword for the people to cut away any crime by private individual or public servant. The constitution of the 2015 grand jury is composed of 64 pages, a large part of which are annexes to procedure, including the notarial procedure of the Chamber of Notary of Quebec and the Rome Agreement for the description of the general state of operation and protection aligned on the International Criminal Court. All participants and their family in the activity of the 2015 Grand Jury of the People of Canada are subject to the international diplomatic immunity at level 5 and are protected by the signing of the Rome Agreement by Canada. Grand jury in Anglo-American law, a group that examine accusation against person charged with crime and, in the evidence warrants, makes formal charge on which the accused person are later tried. Through the grand jury, layperson participate in bringing suspect to trial. Though it hold judicial inquiry, the grand jury does not decide guilt or innocence, that is, in criminal court. Its function is inquisitorial and accusatorial, sorry for the massacring those words. Unlike that of the petit jury, which tries case, the grand jury's function is to decide whether there is probable cause or prima facie evidence to believe that a person has committed a crime. Should it so decide, an indictment, a formal accusation of a crime, is returned, and the accused must stand trial before a petit or trial jury whose duty is to determine the question of guilt beyond a reasonable doubt. The grand jury enjoy greater independence than the petit jury. It is instructed by the court prosecutor on question of law and fact, but its investigations are relatively free from supervision. Although the jury works closely with the prosecutor, it is not formally under his control. The grand jury is a court of its own right, I may add. But what I've just read is an excerpt from Encyclopedia Britannica. The grand jury plays an important role in the criminal process, but not one that involves a finding of guilt or punishment of a party. Instead, a prosecutor will work with a grand jury to decide whether to bring criminal charge or an indictment against a potential defendant, usually reserved for serious felonies. Grand jury member may be called for jury duty for months at a time, but need only appear in court for a few days out of every month. Regular court trial juries are usually 6 to 12 people, but in the federal system, a grand jury can be 16 to 23 people. Grand jury are tools used as part of criminal procedure to bring an indictment against a defendant. However, they're not always required and in some cases not even used. So how does a grand jury work? Read on to learn more or listen to me. How does a grand jury differ from a preliminary hearing? While all states have provision in their law that allows for grand jury, roughly half of the states don't use them. Court often use preliminary hearing prior to criminal trial, which are adversarial in nature. As with grand jury, preliminary hearing are meant to determine whether there is enough evidence or probable cause to indict a criminal suspect. Unlike a grand jury, a preliminary hearing is usually open to the public and involves lawyer on both sides and a judge. Not so with grand jury, which only involves the judge and prosecutor. By the way, the judge in a grand jury are the 23 jurors. There is no single judge per se. Sometimes a preliminary hearing precedes a grand jury. One of the biggest differences between the two is the requirement that a defendant requested a preliminary hearing, although the court may decline a request. Grand jury proceeding. How a grand jury works is much more relaxed than normal courtroom proceeding. There is no judge present, as I just said, and frequently there are no lawyer except for the prosecutor. The prosecutor will explain the law to the jury and work with them to gather evidence and hear testimony. Under normal court rule of evidence, exhibit, and other testimony must adhere to strict rule before admission. However, a grand jury has broad power to see and hear almost anything they would like. However, unlike the vast majority of trial, grand jury proceedings are kept in strict confidence. This serves two purposes. One, it encourages witnesses to speak freely and without fear of retaliation. Two, it protects the potential defendant's reputation in case the grand jury does not decide to indict. And I would also like to point out here that they don't have to keep it in strict confidence. They can make it public too. It's their choice. A grand jury is a court of its own right. The grand jury decision and the prosecutor discretion. Grand jury do not need a unanimous decision from all members to indict, but it does need a majority of 50% agreement for an indictment, depending on the jurisdiction. Even though a grand jury may not choose to indict, a prosecutor may still bring the defendant to trial if she thinks she has a strong enough case. However, the grand jury proceedings are often valuable test run for a prosecutor in making the decision to bring the case. If the grand jury chooses to indict, the trial will most likely begin faster. Without a grand jury indictment, the prosecutor has to demonstrate to the trial judge that she has enough evidence to continue with the case. However, with a grand jury indictment, the prosecutor can skip that step and proceed directly to trial. Before we move on to the next slide, allow me to throw back my face into here. There are some portion of this presentation that are pictures or video that we had. I will not play those. I will make comments instead. There is also a place in this presentation for a lot of explanation. So from time to time I may differ or diverge from the presentation in what you're reading on the screen right now. Yeah, so thank you very much. 2015 Grand Jury of the People Initial Process. A constitution was written for the grand jury proceeding in order that the participants are fully aware of their responsibility and duty to serve on a grand jury. The grand jury constitution was open for a period of time for the proposal of amendment or modification. That time frame is 1 year. In the case of the 2015 grand jury, it is not. You could do it shorter if you organize your grand jury. The grand jury constitution also outlined the general obligation of all members and the process that would be followed. In other words, the rule that self-ruled this said grand jury. There were 7 drafts in the development of this constitution. Drafts were reviewed by a committee of 3. The constitution was submitted to the grand jury itself after the draft for consensus of approval. In other words, they all signed into it. The period for the potential registration was 1 year for jury candidate. The draw was held on June 15, 2015. There were 4 preliminary hearings publicly held through Hangout prior to that date. Just like to point out the date again of June 15, 2015. This is the kickoff date officially of our grand jury of 2015, especially because, yeah, the grand jury was 800-year-old on that day specifically. This grand jury of 2015 was initiated by Denis Paiement, a gentleman living in the national state of Quebec. Prior to the grand jury, the case was presented before a notary public for arbitration, Monsieur Ghislain Poudrier. And I would like to point out here, as I mentioned, there are going to be some comment, that when there is an absence of judge in a said area, wherever this area is, and there is a notary public available, you can legally, lawfully, and constitutionally actually take the trial before this person because they are officer of the law. So yeah, that can be done. Just saying, that's a thing. So let's keep going. The defendant, CSST, I would like to point out at this acronym, 4-letter CSST, remember it because you're going to hear about it in this presentation. That means Commission Santé Sécurité au Travail. And if we translate in English, the closest thing is Worker Compensation Board. It's an insurance for worker that everybody that lives in the national state of Quebec and work is supposedly under. So let me read that again. The defendant, CSST, was summoned and appeared at this hearing, sending 2 employees to represent the corporation. Where were they sent? In front of the notary public for arbitration, as stated on the previous line. From that point on, another comment of mine, everything that was done in this case, including the grand jury itself, is a authentic act before a notary public. So all of this is technically public. Meeting was held with the corporation lawyer after this hearing in the Quebec City Courthouse to present the full claim of right based on LATMP. Pardon my French here again. It's a law in the national state of Quebec, and it means Loi sur les accidents du travail et maladies professionnelles. And I gotta be honest with you, I don't know what the equivalent is in English. So I will loosely translate to law for protecting against workplace accident and professional sickness. At this point, this was a civil case. The notary public reviewed the case with the accused, so CSST, present and presented a judgment in favor of the plaintiff, so Mr. Denis Paiement I was talking to you about. 23 items were reviewed to determine if the accused party was operating according to their own legislation, LATMP. The accused was found guilty on all 23 counts of failing to respect the LATMP, which is their own and only law that they operate under. So remember, CSST is the equivalent of Worker Compensation Board. And this, let me remind you, is all before our notary public before the grand jury. So when we got to the grand jury, so in front of the people, it was pretty much a settled case. But let me tell you more. Why would you do a grand jury if it was a settled case? Well, there is a way more than what I can present to you in the actual presentation. I had to cut short in some areas, so yeah, these are one of those. All right, here's the fun part. The 2015 Grand Jury of the People of Canada, the signature of the 23 juror. Let me read the text here. Electronic signature were sufficient to confirm judgment. Not all juror could be present for the lecture and signature. There are 2 pages of that. Let me put back my face, like so. A grand jury needs 23 people to be formed in Canada historically. We have already seen in the slide that I've presented that the judgment for the grand jury is valid after they get 50% of the people to sign it. In the case of the grand jury of 2015, when the judgment was submitted to um, the juror, not all of them could be there, but they've heard the recording, and they had 30 days to send the committee of the grand jury a letter saying, okay, I am one of the juror and I'm not in favor of the judgment, so bar my name. Well, in the 30 days reading the judgment in public, none of them took their name down. And most of them were present, as you see on this slide right behind me, like so. And the next page, you will see some blanks. Here, let me read that, and I'll get my face out of the way after I'm done reading this slide. So the timeline, 2014 to June 2015, the development of the grand jury's constitution and opening of the registration of the juror. 1 year later, and there was some stuff in that year, which I've already read. Random draw of the premier juror. This is public on my YouTube channel. September 19 and 20, 2015, the hearing of the case. October 3rd and 4th, sorry for the typo on this one. Hearing of the case, which is October 4th, the next day. It should have been one line up. And October 16, the proceeding of the juror, in other words, the reading of the judgment. The next day, reading of the judgment to the 23 jurors, signature of the judgment of the juror, what you see here. And I'd like to point out, I'm going to put my face off, that, can we see it actually on the recording? I'm not too sure, so can I actually move this window for you to see it? Yeah, I can. Look at this, down at the bottom here, here, left of the picture. It was signed by our notary public, as I mentioned to you. So let me put back this where it was. And skip to, oh, well, stupid eye. Here's zoom in, the signature I was mentioning about. All notarized, well, sorry, let me rephrase that. All is an authentic act before a notary public. So I'd like to point out, since I just said that, that if the grand jury would have had anything illegal, the notary public, which is an officer of the law, would have told us this is an illegal act, or this is, an unauthorized act, whatever you call it, forbidden act. The funny part is that even though the government of Canada, and thus the province, have ditched grand jury, well, they couldn't do that legally. They couldn't get rid of them. They simply vanished out of public knowledge, and they stopped being used by the so-called justice system. That's all that happened. They had no power at any point in time to tell the grand jury, you do not exist, we don't want you anymore, that is illegal, that is unlawful, that is no. It's historically legal, lawful, constitutional, and it's been 800 years in existence that grand jury exists, and the very fact that they still exist in the United States to this day, and they use them from time to time. In Canada we simply use them until a certain point, and then it faded out of memory. We need to bring them back. So this is why I'm talking to you about a grand jury. Let's put my face off and continue. All right. October 20th, continuing of the timeline, 2015, meaning in persona of the signed judgment, so the people came in and signed what you just saw. October 30th was the judgment compliance deadline. So we actually served those people who are concerned in the judgment in person, and they had a certain time to comply. Since the following day of that, October 31st, 2015, until today, we've got a public mandate, which is basically the judgment of the grand jury. October 20th to December 5th, notification of the judgment to the accused party. Because some of them, we may not have met with them on our first try, and there was a ton load of people to notify, so we had to go after the execution of the judgment. But yeah, we did our best to notify them. February 3rd of 2016, the official dissolution of the tribunal itself, maintenance of the committee, prosecutor mandate, and especially the judgment. The court had no more hearing, so there was no point in keeping those 23 courageous souls that were our first or juror, sorry, for the grand jury. So we dismissed them on the date that I've just aforementioned. So here's the mandate that came out, the public mandate that came out on November 7th, 2015. The prosecutor, so yours truly and six more, under the authority of the tribunal and the people above named in this judgment, to conduct a criminal investigation, serious and severe, for the fact mentioned above, by all means useful and necessary to prevent crime, such as the equivalent power of a judge of instruction in law of France. So let me quickly comment that. We didn't have time or the knowledge to surrender the power of the prosecutor after there's no prior case, let's call it that way. So we took the power of a judge of instruction in law of France and said, now, except which apply only in France, now applies to the prosecutor to keep on the investigation going. So let's get to the next slide. This is the grand jury of the people of Canada by number. If you want to actually read them, you go ahead. I will, you can pause the video. I will just point at 100 in criminal charge are all prosecuted in summary conviction, guilty on all count. So I said, and I read, and that is a fact, that the grand jury does not make criminal conviction. It needs a petty jury or another form that is before one judge only. So after the grand jury, the prosecutor inherited the mandate that I just mentioned. We took some time after the grand jury. We all already had the hearing, remember. But we reviewed each and everything that happened to it, and 110 criminal charges were indeed prosecuted against all the people that were involved in the grand jury's finding. As it is one of the duty of the grand jury. They cannot indict themselves. So the prosecutor that were at the grand jury were also the prosecutor after the fact in a summary how they call it, summary procedure, exactly. And we did all of that here on the next slide, and I will pause it again so you can actually read. And there's one more of that. This is a full list of criminal charges that were found during the grand jury. Everything that you see here. And I know now I should pull up the screen a little bit like so. There's a few more. Right? I'll skip to the next slide like so. Here's a few more again. Damn, I'm not moving the right window now. There we go. So pause it if you really, 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 but that's that's more than half the criminal code. So let's get going. More numbers for those who like number. The case detail. All right, what was presented at the grand jury? In fact, there was 7 cases in total. 4 related to CSST, Commission Santé Sécurité au Travail. 1 related to the Fédération of Quebec Maple Syrup Producer. At this point, I would like to point out that the National State of Quebec and the Maple Producer Association is a total mafia. They control the product, and Quebec control between 80 and 85% of the world's production. There's a little bit in Ontario, some in the United States northern portion, and somewhere in Europe there's a few that also does it for the rest of that. So yeah, it's total mafia. 1 case related to Fédération des Caisses Populaires des Jardins. If you don't know, that is a credit union. And last but not least was a constitutional case. I would like to point out that this time I did not present a constitutional case. I will read it just below among the case. But I took it as my main battle horse after the grand jury. So here are the people that actually presented the case. Marc Legault was represented by Chantal Benoit. Yves Saint-Martin represented by me because he died a week and a half before the grand jury. So I had to step in and present his case. Michel Thibodeau, which died a couple of months after the grand jury, both of their workplace accident that were never treated because CSST is a criminal organization and they never recognized it. Monsieur Paul Leblanc, which was against the credit union. Denis Paiement, which was the main case and represented by me and tightly tied to the grand jury. Without it, the grand jury would have never been. Jean-François Dubois, which presented the constitutional case. I don't know where he is today. I've had no contact since the grand jury. And Miss Angèle Prince, which became my friend after the grand jury. She died a few years back in circumstance where the state is completely guilty of her death. I will skip on that. I will keep on going. This is emotional for me. Sorry about that. This presentation will focus on only 2 of the cases that were presented before the grand jury. 3 of the 5 remaining cases were circumstantial evidence. So me, like I mentioned, I was representing mainly Denis Paiement. So we'll talk mainly about this case. There is a portion in this about other case we'll touch briefly. They were not the case I was representing. So here is Monsieur Denis Paiement, the case number 1, tightly tied to the grand jury. Of course, I will scroll up a little bit the screen here like so, just so you see that here in the left lower corner of this picture, you see Will because he's in a wheelchair, and that's the work accident that he was a victim of. I'm not sure that you want to hear the entire story at this point, but I will briefly touch on it. The entire story is over. Well, it's still ongoing to the best of my knowledge to this day. I'm gonna move and respect. I'm gonna move on the other side. Monsieur Denis Paiement went one morning to work, which was a lumber mill, and that's the best of my knowledge and memory. So I'm gonna keep it short and sweet. There was some maintenance in the machine that he was working on. He was part of the worker that were supposed to be there and doing the maintenance on the said machine. There was a operator, I guess, for lack of a better word, or some type of electrician or electrotechnician that was in charge for the revision of the circuit, the electric circuit of the damn thing. And while my friend was doing whatever he was doing on that piece of machinery, well, the other guy for some reason, started up, and my friend lost both his leg above the knee. And that is not related to the fact that he is named Denis. I cannot do this in French because, yeah, Denis are not pronounced as Denis in French. So, yeah, bear with me with this one. It is an horror story that is still ongoing this day because of the incompetence of the Worker Compensation Board of Quebec. It is sad beyond sad. So, here we see in combination to the left, Monsieur Ghislain Poudrier, our notary public. This is evidence that he actually witnessed the evidence. And on the right, Monsieur Denis Paiement in his wheelchair. And you can see above the knee that there are no legs. Well, maybe below the knee. Sorry about this one. But that's his house. So also, we're gonna dive into his case here. So I would point out to a few things. Um, we're gonna start from left to right, so this way I remember everything. So what you see here is the result of CSST coming to Denis' place to perform what they call a home adaptation for his condition. Well, there's several things to say about that. I won't blow your head for 2 hours, but I need at least 2 or 3 minutes of explanation here. This home adaptation happened something like 11 years. I don't have the exact date to this point. Forgive me about that, please. Something like 11 years after the accident. This was his first home adaptation. So there is quite a problem with just what I've mentioned, but let's skip because, yeah, 2 minutes, no more. On the far left, you will notice two things. First, the door is open because you can prove it with the bright light that's coming in. The door is fully open. And there's a heating system, a vertical electric baseboard. I'd like to mention about that when they did the adaptation, Denis already had electric baseboard throughout this house. They've redone pretty much everything, including the electric. So when they were quote unquote done, they had removed every electric baseboard that Denny had in his house, perfectly adapted for this house since its construction, and they've put nothing in exchange. All right. Next thing. Remembered all this shit. Next thing. The brown door behind the Notary Public. Why is there a door to the right that would lead outside if the door that leads outside is to his right but to our left? Fully open. Well, this is part of the home adaptation. This is the elevator that CSST came and installed for Denny to access the basement of his house as he would if he had legs. And the evidence that he had a basement, if you look to the far right, the brown thing that's right there, that's the staircase leading down there. Anyway, so next is standing is the Notary Public that came here to verify that everything was conformed to legislation. Well, lo and behold, if you look immediately to his right, well, to his left, but to our right, there's an electrical outlet. Well, it is at the same height as a regular home, but in the code, there is a height for people in wheelchair. They didn't respect that because you can see the man is standing right next to one. When I pointed that out to the general contractor who was responsible for the supervision of all of this, he says, "Well, I've never adapted that a home for handicapped people." Well, regardless, whether you've done it or not, you did take the contract, you did have legislation that are very precise in the building code for this type of situation, and you ignored it. Well, let's keep going, all right? Because this case is freaking heavy. Next thing I'd like to point out is Denny in his wheelchair. Yeah. Funny enough, you can see the floor is was installed during that said construction, but it provides more problem than solution. First of all, it is very cheap wood. It's not. I don't think it's even wood. It's kind of plastic thing, and so then he cannot do as we all do and remove his boots when he comes in winter. He only has his wheel, and it wets the damn thing. And yeah, and once the water hit that thing, well, that's a big problem. Before that, he had some press wood or whatever plywood that was there, and it was perfectly fine for his condition. So it is an improvement, but at the same time, it is a burden improvement. Next thing, very quickly, and last one, not so funny. Here you can see a window. And why is it so freaking dark in there? Well, because it leads in the garage that they've installed for Denis. It's a carport type garage, but anyway, the second thing I'd like to point out is that on that wall, before they came and adapt the house, there was a very large window that they had to remove because of the elevator. It was the entire side of the house. And throughout the house, on the first and only floor, there was three more of those giant window. Well, because they needed some wall space, they've changed every window, part of the adaptation. Well, I don't have picture here for you, but I hope you make me the favor of believing me. They took out every giant windows of Denny's place and they replaced it by windows that Denny cannot open because they're behind the counter or they're too small, like this one. Nothing gets in. So this is why the door is wide open. That's the only true draft that he can have in this house from this point on. All right, let's get going. I had to give you these explanation. Then he was injured in a workplace accident July 21st, 2003. Yeah, so this picture that I've just shown were around 2012, 2013. So this is why the 11 year before they adapted this. As a result, he lost both leg above the knee, as I mentioned. Then he was living in very poor condition and appeared to have fallen between the cracks within the workplace insurance benefit program. Not quite so, they didn't want to hear about him. Denny's living condition and subsequent treatment by the CSST was compared to the CSST's own legislation, whereby proclaimed certain level of care to be provided to injured worker. It was very clear in the case of Denny that CSST was not operating under their own expectation. Thus, why 23 infractions were noted under that legislation. And here I'm gonna just, I could give 23 example. I could give more because each piece of the legislation may be based on several events. So here that a compensation is transportation for the worker. Of course, Denis has no leg anymore. So let me remind you that a car is operated with at least 1 feet. Some people, they don't know how to drive, say they'll up. Anyway, in Denny's case, when he got injured, and we placed a claim about that, which I will talk to you right on the next slide. Transportation. All right, remember that. Let's skip to the next slide. Well, this is one of the things that Denny received from CSST. They paid for that. The Worker Compensation Board of Quebec paid for that. The reason being is that Denny is entitled of a form of transportation under the form of a scooter. If Denny would have lived in a city, he would have had a scooter pretty much like a grandma that you see running them, an electric scooter, on the sidewalk in the city near you. Well, he lives out in the mountain. So that was the appropriate replacement as a scooter, so he could pull his garbage bin all the way to the road. Of course, in summer it has wheel and not those tracks. So they gave him that, so they thought that they would keep him busy, and so this way they didn't have to overlook for him for anything else. And here's where I come to the transport again. Here you see several things. This is a photo montage done by me. I've done that in a great total of 6 minutes, something like that. And you can see, if you put Denny in the driver's seat and we ignore the fact that he needs special equipment to operate any motor vehicle, he needs a space for his wheelchair, right? He needs a space for his grocery in the cab, in the box of the pickup truck, and he needs a platform for the quad. Well, originally, and you can also see a garage in the background here. That's not without a reason. So let's start first. When Denny had his accident, he had a car. It was a standard and clutch, with a shift stick and a clutch. So all of a sudden, the car he came in the morning at work, then he lost his leg, was rushed to the hospital by an ambulance. Well, this car, he could not drive. Even if the ambulance would have dropped him right next to his car, how can he drive it? He has no leg. There's a clutch. There's a, a gas pedal. There's a brake. You got no feet, man. Anyway, so we did put in the claim for a vehicle replacement, which is normal. I mean, and now in his condition, he needs a vehicle. Like I mentioned, he lives in a mountain that can also take care of the snow in winter. It's not because you get a work accident that all of a sudden your house now, oh, well, you gotta sell your house and gotta move in somewhere in an apartment in the city. Well, then he never lived in a city, never been close to any city. He needs truck like this to put all of that. And they didn't understand jack shit because they understand jack shit, and I'll prove it on the next one. All right, listen to this. There's a lot I could tell you. All right, this door was installed by the CSST under the pretext that every home must have a emergency exit in case of whatever. And remember, they've installed an elevator that led to the basement. And after they've done, you can see the door's brand new on the picture. Of course, it was right next winter after they did the so-called adaptation. They claim that then he was autonomous, he was capable, he was able in his wheelchair to pick up all the snow that you see there. And in case of an emergency, whatever that is, whenever that happened, doesn't matter if it's currently snowing, you should be able to get out that door and be about your own merry way with your wheelchair. Well, first of all, we don't see it here, but the bottom of this, when you walk on it, it's gravel. So here goes the wheelchair's excuse. Second thing is, how do you shovel snow in a wheelchair? Especially if you have to go the long way around because you can't open the door that's full of snow. So yeah, you gotta come in from the right side of this picture and make your way to the door in a wheelchair and shovel. Yeah, great. And what more on this picture? Well, the snow in the forefront, that's coming from the upper part of the house. The main door is where I am standing to take this exact picture, and I'm pointing down, right? So when Denny needs to shovel his main door in a wheelchair, let me remind you that, well, the only place he can push that snow is on the left side of the door. That's what you see. So everything, even if shoveled down, well, it all comes from above. So great, he's independent. That's what they said to us. He's so independent that the next thing, the horror starts, but I've already said so. This was less than 6 months after the home adaptation. Then he needed a flat surface to park his car and, of course, deploy the wheelchair in order not to get stuck. So what's best than concrete? It would be good. But let me point to several things here, on this picture. Picture's worth 1,000 words. Well, first, there's water. So there's a problem. It's not in the right angle to evacuate the water. So imagine that. You come in with your wheelchair, you deploy it onto frozen water. Wheelchair wheels on ice in January may not be the best for anyone in a wheelchair. Also, because of the water accumulation on top of the concrete slab. Well, with the powder that you see here is actually the concrete that's been so wet for so long that it's turning back into concrete because it didn't have time to dry in or to cure in the first place. After they were done, then he started using it the next day. Pretty much, it didn't cure long enough to. Anyway, I don't know anything about construction, but I do know I do know this. All right, next thing. The slab, which is cracked all the way, on the left side, the white portion that you see is the vertical wall of the house. It's the side of the house. This slab on the left is not the top of the wall. The cement, or the concrete tour of the house is lower than that. So on the left is the wood structure. So all this weight is pushing against the wood structure of the house, the internal wood structure, the second or the main floor, if you prefer. And last thing, all of this is built on clay. When they dig to to pour that in, everything that was under the first layer of rock that was installed by whoever before Denny got there, well, they immediately directly hit clay, almost on the surface. So all of this is on clay. I don't know how much that weighs. All right, next one. This is the inside of the elevator. And you cannot see it here. I'm supposed to have a video, which I will not play, but it's published on my YouTube channel once again. This is water. And this is the bottom of the elevator. Once the platform is raised on the second floor, you can actually, with a key that you can see there, you can actually unlock the bottom door. And this, on your right, is the electrical and electronic operation of the elevator that they've installed. So it's sitting directly into, I don't know, they must have had 3 or maybe 4 centimeters of water. And me, that day when I took that picture like an idiot, I put my feet right into it. Then he said to me there's water, and just like on the picture, it wasn't clear even in person, so I kind of had to step into it. I didn't want to put my hand into it, but thinking about it years later, I could have thrown anything else but my foot in that. Yeah, because it's sitting in 240 volt. I don't know much about electric, but I know it doesn't mix well with water. It doesn't produce good results. Anyway, this on the right is the state of his wheelchair. It's so poorly made, so cheaply made, so badly made that he has to sit on a piece of plywood in order to keep it open. You can see the crossbar below, but for some reason they don't hold the chair in place. And to solidify it, he needed to sit on something like that. So yeah, here goes. So let's keep on going. I'm going to take a little bit of the number that you saw earlier, and I'm going to comment them here. So then he received letter of change from CSST in the amount of over $250,000, of which 110 was the home adaptation that I've been talking about for the last 15 minutes. So that's not that much. And he did receive a compensation some years ago after the accident for the loss of his leg, but that is not discussed here at all. That was settled years ago, and that was it. Less than 3 months after the grand jury, CSST was closed. CSST changed the name of their organization to CNESST and was officially brought back into the Ministry of Labor. This was directly in the judgment and in line of the judgment of the grand jury. And for those of you who wonder what the E mean in CNESST, means ethic. They got none at that place. So anyway, the CEO of the said CSST resigned, Michel Després, and shortly after, the Minister of Labor also resigned. This was directly in the judgment. That was Sam Ahmad, a member of the Liberal Party of Quebec back in the days. Because of the grand jury, several more of the member of the Liberal Party of that period also resigned in the year following the grand jury. This is why they have the La CAQ, which is the official acronym of the actual national state of Quebec so-called government, really a criminal corporation. So the entire case is backed up and confirmed by a previous judgment, Eldridge versus British Columbia. I'll shortly touch on that. There's only a few things that are important. It is stated somehow in this judgment, I'm not perfectly quoting here, I'm working off memory, that if a health service is not provided by the province and it's still needed, it doesn't exist, in other words. They still have to pay for it because it's needed. And that's as simple as that. And this is what we're talking about here, generally speaking, in the case of Denis Paiement and this grand jury. This is why I talked to you about, yes, Denis needs a truck. And yes, it's up to them to pay it. And no, Denis does not earn enough on a monthly basis to afford the vehicle that he needs to compensate his handicap. If this guy had his leg, he could buy a Honda Civic 1992, pay $300 for it, and be perfectly happy. But in his condition, he needs something solid, reliable, recent enough so it doesn't run into eternal problems, and it needs to be adapted to his condition. So there's two ways of doing that. Providing a chauffeur and a vehicle that will do that for him, or provide him with his own vehicle. So this is an example of what Denis needs, even if it's not as direct part of healthcare. Here, and the next one's a little bit funny. When we went to inform CSST more than once, the little red car that you see with the trunk open in the background is Denis' car. Because that's all he could afford and is really not adapted to his condition. As an example, why the trunk's open? Because I was the one who took the wheelchair out and in of the trunk. If Denis has to do that himself, well, imagine the scene. Disembark the wheelchair behind the car wherever it's parked, whatever is on the ground. Right now we see asphalt, but it could be dirt, it could be mud, it could be anything. Put the wheelchair in pieces because you have to remove the wheels so it fits, right? And close the trunk. How do you do that when you're sitting on the floor? Well, you could always have a rope, and then what? You drag your ass, literally, because you have no legs, to the driver's door. Somehow you pull yourself up into the driver's seat, and with your ass wet, you go. So the fun part about that is not what I just said, is that the people that you see walking there, this is middle of nowhere Quebec City, all right? There's this building and CSST is in it before they moved. And they're on strike. And Denis and me are there in the middle of them. So, yeah, we went several times, CSST, because Denis was saying to me when I first met him, he was saying, oh, they know my file, they know my file. Yeah, I said, but they don't know you. So let's go. So we went numerous times. Here's another time where we went, which is not the same day. This is me and Denis, of course, because Denis is in a wheelchair. Who's holding the camera? Who's taking the picture? Me. But there's a chair right next to him. That was my chair. And so we made sure that they see Denis. That's the parking of the employee of CSST. That's the building in the background where they work. We were there 11 days. They've noticed us. So much so that by the end of the 11th day, they sent the cops after us because I think a couple of their so-called employee were about to throw themselves off the first floor for seeing us there for 11 days. They were sick and tired, I can tell you that. And we told them pretty much everything that we needed to tell them. Here, I think Denis is holding the LATMP or some part of the claim. It's either in the binder that you see on my chair on the left, or he has it in hand to remind them of their duty and what they're supposed to do. If I flip to the next one, this is day 7. By that time, I deployed the table. We had some drinks. We were a little bit more organized. And on the sign there, I won't bother you with reading them. It's too small even for me on the screen here. But basically, we're telling them that they're a bunch of crooks and they're not doing their job. So this is evidence where we were. Took that from the chair and the table that you just saw. quickly to the next one. This guy is Oz, was with us, supporting Denis' morale throughout the claim that he still have to this day against the national state of Quebec, and throughout the adventure. Most patient and most lovely dog that there is. Skip to the next one. We're gonna start crying here. Those home adaptation I was talking to you about earlier was nothing but a sabotage of Denis' house. The list is too long to do it here, to explain exactly what happened and how much they trashed the place. So I'll cut short. We drag the regional inspector for the assessment of the value of the house out of his office. They never do that, to be honest. But anyway, we got him to come to this place because we were claiming that this house value was zero. And from his office for weeks on end, he said, "No, I decide what's value, and you have nothing to say." And we were pleading our case. Come and see it. Come and see it. Was there a fire? No. Was there a flood? No. Was there blah blah blah? He asked a bunch of questions, but he never asked the right question. Was there CSST? So anyway, he came out, assessed the situation, looked at us, looked at Denis, says, "Okay, yeah. This house value is zero." And he went away and filed that into the regional office. Therefore, Denis' tax went to zero. But that's not the main story. Denis, from that point, realized that the house value was zero. Every amount that he was paying was just money thrown overboard because the final resale value of the house is zero. So he stopped making the payment. Instead, he dropped the money, or was supposed to drop the money, into the notary account for the day, 3 years later, when they came for the house and actually were able to repossess it. But by that point, Denis had paid a grand total of $11,000 to live there, a grand total of 6 years, roughly, five something to 6 years. So, did they really repossess the house, or did they took a very heavy burden off the back of a handicapped guy? We'll never know. But by that time, we were well known by everyone because we've shaken some shit around. So this picture, beautiful picture. This is where Denis was living. This is the road that he needed to drive on with his little red car because he didn't have an appropriate vehicle. And the reason why I'm going down that road at this moment is we've just received a call that the bailiff were here. But in Quebec, I'll skip about that because that's a story of its own, was accompanied by, a few minutes later, and I do have the video about that. It's on my YouTube channel, as everything else. There must have been at least, I didn't count them, I didn't have the material time to do that, but just a minute after this, just right around the corner, 6 cops came out of the wood from the left, from the right, from the top, the bottom, the front, and even behind me. Because we were so-called a menace to the bailiff, or I don't know what stupid shit they came with that day, but they were a shitload of cops. There's so much to say, but let me skip to the next one. Otherwise, we'll be here all night. So in the forefront, you can see police car. Those 2 assholes on the left, the guy and the tiny woman, are cops. And on the right, they're EMR people, because what you see here is an ambulance, of course, and the sticker that are all over says on strike. So basically, everybody is on strike in the national state of Quebec. But there's several things to point out here. So let's work backward this time. What's happening here is, after an hour and a half of negotiation between Denis and the cops, I was only there to take the picture. I didn't speak to any of the cop that day. I was just there to document. But they agreed that they couldn't physically remove him. There's no way. This is illegal. Cops cannot physically put their hand on you, even if they're here to repossess your house. Nobody can actually, and does not have the power to physically remove someone. So the only way they found, which was all planned by me, was to send the ambulance and take charge of Denis. Since the ambulance cannot dump people on the side of the street, especially Denis, which is actually sitting on his ass. Why is he? Because I've stolen his wheelchair that day. So they couldn't do anything with him except bring him to the hospital, which they did. We're gonna skip that chapter in a second. We're gonna skip to that chapter in a second or two. Let me make you just a quick few things. Right, I was talking about the large, beautiful window that Denny had before the so-called adaptation. Well, in the background, in the middle between the guys and the car or the ambulance, you can see a tiny, tiny window. That's the kitchen window. They've replaced two large windows by this small piece of shit. All right, that's the main door where Denny is sitting. That's the deck that they've installed. But there's no bar to old people. And this deck is far from being even to the ground or flush to the ground. Look at the angle of the vehicle. That'll give you an idea of what's the angle they're walking on. But at the other end, at the far end of this little stretch of deck, that is where the white door was that I showed you earlier. So there's at least a door I plus of directly falling. You know, if you walk too far, you're drunk. Well, then you're in a wheelchair, and he slides past the door, or because there's ice or Jack know what shit else there is. He falls down. All that. All right. Next thing, look at the cement slab. First of all, on the left side, you can see it's cracked perfectly in the middle, where the weight is separated from the left to the right part. But on the right, if you follow it to the little deck, you can see that there's a darker line. Well, that's how much the cement slab has dropped since it was installed. And so Denny, each time he comes around the corner, he needs to make sure that the front wheel of the wheelchair are not getting stuck into that. Otherwise, it's a face plant directly. You know, when the smaller wheel are completely blocked all of a sudden, the only way is forward for the passenger on top, which constitute the weight of the entire thing. So that's an immediate face plant. So he needs to lift the front wheel. What you see there also, the white door, is the elevator. And if you look at the bottom of it, it's no better than the plastic part. It's also broken. Everything is broken in this house. This is why this is happening, what you see here. So then he lost his house. He didn't lose much of his equity because he didn't pay much in over the year, but he did lose his house because of $110,000 that were so-called invested by CSST on behalf of the Worker Compensation Board, and the home was, by rule of them, deemed safe for a handicapped person. And the next step, this is when they took Denny out. All right. By that point, the cops were gone because that was one of the condition, and they took him to the hospital. As evidence, this is the step of the hospital. And if you read the title, 1 week later, hospital eviction by Garda World. My good friend Garda World, I'd have something to say about you, but I'm gonna just get to the point here. So then he has been brought by the ambulance at the nearest hospital from his place. They didn't know what to do with him. And for a week, they simply pissed him off to try to get him to run away, but then he wouldn't. So they sent the cavalry. The way they've kicked Denny out, they took all of his belongings and they simply dropped it at the door. So then he didn't have any clothes, anything. So he had to run from his bag, for his bag. And by the time he made it to the door, they've locked it behind him. That's as simple as that. That's how they kicked him out of the hospital. No human treatment, no nothing. You're discharged, you've got nothing, you're on your own. There is a zero problem with you. Really? Didn't I came in an ambulance and without a wheelchair? So he was sitting outside in the wheelchair of the hospital, because remember, I've stolen his. I still had it when he left in the ambulance. I didn't give it back. I still had it. So I was there to give it to him, because I kind of knew that he was outside. He still has a phone at this point, and he called me. Yeah, they kicked me out. Yeah, all right, so I'm coming. So, expecting the next chapter of this entire story, I show up to the hospital on foot. And I get there, I climb the hill, and suddenly I get to the front door, and here's Denis in his, in his hospital wheelchair. Yeah, what you doing, man? Yeah, I've been kicked out of the hospital, man. So yeah, I go in. I'm gonna skip on that part, but it is very sad. Garda World, Garda World. I will spare you the shame of repeating that story in English. They called the cops on us because he was yelling at Garda World, "You gotta take him in charge and take him to your place." And yeah, so here I am in front of the hospital saying, what? I'm walking to the hospital to come and visit my friend. He's on the sidewalk. And I walk in here, gotta take him in charge. How the fuck do I do that? And well, who are you to tell me that I need to do that? How do you know me? Well, I'll tell you how they know me. Because at that point, we've been to CSST quite enough, right? I showed you. Well, in front of the CSST office, most of them, if not all, guard the world. So yeah, we were well known, and I'll skip also all the part involving the police, cause yeah, the Quebec City Police, they've had enough of us. So much so that during this entire adventure, at one point I get to the main cop shop in Quebec City, and I'm carrying boxes because obviously Denis in his wheelchair, he needs his hand on the wheel to go forward. So here I go. This is all my YouTube channel, all in French. Um, I get into the cop shop, and she looks at me, and I'm looking at her, and she says, "You're gonna have to open the box." I'm like, what? I'm not opening the box. Who the fuck are you? I need to search. This is a cop station. What? I'm carrying a box to the courthouse right up here. There's a bunch of lawyers passing left and right. They all have more than I do. Why the fuck would I open? She says to me, how did she said that? That was in French. I got it in English. It's a little bit harder. But she says, "Don't you wonder why you undesirable in a cop shop?" And then you were right there. We listened to her just stating that, and if we could, we would have rolled on the floor right there. Oh man, if I'm undesirable in a freaking cop shop, you've made not only my day, you've made my year. But remember this, you freaking piece of shit clown. When you come for me and you drag me here, you better remember those words. All right? I'm gonna be on my way without you. I don't want anything to do with you clowns. So, anyway, back to the cop and this. What you see behind me. So then he tells me while he's sitting there, I forgot my jacket in the room. He looked through his stuff and he didn't have his jacket. It was probably they missed it. So I just go in and I go all the way blah 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 out there. So they stay out there. I'm not too sure where the room is. This place is giant, so I'm getting lost for about 15 minutes in there. By the time I figure out where the room is, I go in, I take his jacket, and I come back out. Much easier. Took much less time. And so I come back to my friend, and they're both still in the same spot, right? Because I got a cameraman with me. And my cameraman starts to be nervous, saying, "Okay, are we going now? Are we going?" Then he has no way of moving. I mean, he's sitting in the wheelchair of the hospital, and I'm walking. My car is about 2 blocks down that way. I didn't bring it on the hospital ground because I knew what was coming, right? And I'm no fool. So suddenly my friend says, they called the cops and they're coming. Really? We are in a very tiny region here. I mean, it's huge in size, but there's a very low population. The entire place has 10,000 people. So the cops, they're the same as 1 week ago. They're on their way. Lo and behold, they get in there. And they say the same thing to me. You gotta take him in charge. What? What responsibility do I have of a grown man sitting in a wheelchair in front of a hospital? He's not my fucking wife. He's not my husband. He's not my children. I don't know this. Well, I do know this guy, but I mean, I have no obligation to him. I mean, I didn't kick him out. And remember, they're the same cop as last week. So at one point, my friend's desperate. I know he's about to cry and he's have had enough a week in this shit house. And anyway, so I go grab the car. I come back up. I get Denis in the car. As soon as we drop the wheelchair and about to put in the drive-in and go about our way, of course the cops that were waiting for it just happened to have a verification to do on us. So they pulled me over. I'm not even 10 meters from the door. Verification, just to piss them. Well, you just ordered us to. Anyway, I'll skip over the fucking cops in Quebec. We'll be here all of next year if I have to start with that. While the grand jury was going on, one of our case, Angèle Prince, to name her, also was going into the Quebec. I hate to call it justice because that's really not what it is. Anyway, she was going through and she was reaching the Court of Appeal. And after the Court of Appeal, the only next level in Canada available to judge anything is the Supreme Court of Canada. She was really tired. She's had enough of that shit. By that point, she was in their stupid system for over 15, 20 years. And she lost a couple of things throughout this process, of which I don't know the extent. So we took the case to the Supreme Court of Canada, and we included we've included the grand jury. This is the evidence that we were at the Supreme Court of Canada. Sorry if the picture was cut, but this is officially Denis at the Supreme Court of Canada on the entrance floor, right after security. And we took it there. This is an entire story of our own. So I'm gonna imbrick it in the case of Angèle Prince, because the fact that we went to the Supreme Court, what you see now, I'm gonna remove my face. This. Sorry for being a little slow on the slide. So what you see now is more her story, even though it's always our story. You, I, Denis, everyone, and her. Let's see quickly. I'm just looking ahead, just to revise very quickly. All right. At this point, before I get into case number 2, I would like to remind each and every one of you that this is the story of we. We as a nation, we as people, we as anything that is organic, that is so-called Canada. It is not the story of Denis. Like I mentioned earlier, Denis' case was pretty much won before the notary public. But nothing was done between the time we got the notary public judgment till the grand jury, until after the grand jury, to correct any of the point that were mentioned in Denis' case. I don't know to what extent the grand jury was responsible for receiving $250,000 less the home adaptation that happened a few years prior in compensation for not as direct money per se. Then he couldn't touch the cash and go do whatever with what he wanted. It was specific to 23 points in the LATMP, one of which was of course the wheelchair, the quad that you saw. Also, a trailer was awarded to him, and this is where it becomes real completely stupid. They granted a trailer to him, knowing perfectly well that Denis needed a pickup truck to pull that trailer and quad on it. I mean, a small Red Beetle car like style that I've showed you, I don't remember the brand and name, couldn't pull jack freaking shit. I mean, me, Denis, the wheelchair, and the dog, and it was full to the brink. Nothing else, no grocery, no other passenger, nothing. Anyway, back to the main part. This is the story of we. This is the story of Canada. This is about law, justice, the foundation of our nation. So this is why Angèle Prince come in, let's say, from the side door. And Quebec, national state of Quebec, is not part of Canada. I'll be real clear with you. It's not a legal, lawful, nor constitutional part of Canada, right? This is what the grand jury discover in top of the 100 criminal charge and everything else. It's a sad story of how you all Canadian have been sold. For most of you, unless you're very, very, very old, thanks to you and your service and anything that you did, you've never lived under the real form of the government of Canada, which is constitutional monarchy. This is the form of our government. There's a king, Canada is a kingdom. Or there's a queen, and Canada is still a kingdom, right? So other people got fooled by the national state of Quebec by other mean because it's a fascist shithole. The cops are everywhere, all the time, involved in everything. Everything's criminalized. Each time you try to do something, somebody's gonna get accused. With article, it's funny enough, of the Canadian Criminal Code, because Quebec is indeed not part of Canada, but they couldn't make it so obvious that Quebec was not part of it. Because remember one thing, there are some members of parliament in Ottawa which are elected in Quebec. All of these seats are illegal seats, rendering illegal the Parliament of Ottawa for a long, long time. Quebec is not legally part of Canada by any means. They respect nothing in the Constitution of Canada, so they're not part of it because that's the social agreement. The cops are everywhere, and here we go with Angèle Case's case. Angèle and her family lived on their native land and produced artisan product from the maple syrup their land provided. They wanted to sell their homemade product independent from the Syrup Federation. Production of maple syrup was an ancestral inheritance. This artisan hobby was established long before the establishment of the Federation. And here we're talking about, the Federation of Producer of Maple Syrup, not the Federation of Canada. So they claim freedom of association from the Quebec Federation of Maple Syrup Production, which was denied by all court all the way up to the Civil Court of Appeal of Quebec. 30-35 judgment, all in the same conclusion, doomed to failure, no chances of success. So they've debated, Angèle and her husband, and this is their property that you see here, and here again the cops kicking them out or arresting them for doing a hobby on their own private land and forest. They've went through 30 to 35 judgment in total before, during, or after I met her. So they were getting harassed. Angèle was at risk of losing all of her ancestral land to the Federation of Maple Syrup through a seizure process between 2005 and 2016. So in various states, they put lien on their land and house, and they had to pay from their own pocket money to get rid of those liens. So basically, they got stolen from. She filed a procedure to take her case all the way up to the Supreme Court in 2016. And remember, that's a year after the grand jury. She was advised by the registry to file an injunction to delay the seizure process and protect her land. She did, and after 30 days had passed, none of the defendants had objected to her injunction, therefore resulting in a default judgment from the Supreme Court stamped and filed by the Registrar of the Supreme Court of Canada in Ottawa, Mr. or Monsieur Stéphane Racette. So let me repeat that in clear. She got to the Court of Appeal, got denied, filed at the Supreme Court of Canada in Ottawa, and her injunction was not defended by the defender, and we got a default judgment. Nevertheless, the Federation continued to harass Angèle with bogus claim and fine, each one resulting in court appearance. She bravely, I was there that day, she bravely tore up the three recent judgment in front of the Quebec Court of Appeal and told them that freedom of association, that if freedom of association had been respected, she would not be here today. $350 for each appearance plus other fee. She was found guilty at every count because freedom of association don't apply in the national state of Quebec. You are forced to or you are routed. Angèle asked the appeal court to provide her with a judgment, which they did. Then she had to apply to the Supreme Court of Canada a second time. So yes, we went a second time in about less than 2 months. So everything happened real quick from that point on. Okay, next slide. It was through this lengthy court process that they discovered that the Quebec Federation of Maple Syrup was in a conflict of interest. Hear that. On September 12, 1990, the National Assembly granted the Quebec Federation of Maple Syrup Producer the regulatory power, the power to enforce the Marketing Act and Chapter M35. Don't ask me what Chapter M35. Anyway, the power to prosecute. Well, seems that it is what it is. On November 11, 2011, on November 15, 2011, the judgment of Carole Julien is as follows, which is a judge. No, she's not a judge. She's a liar. The Federation Act in this case, not as a union but as a marketing agency, is responsible for exercising power provided by law. This body cannot not have the obligation to defend its member and the power to prosecute them at the same time. This is illogical. Right, you're here, you exist to defend me, but you have a right to sue me. And you exist under my name. So basically, what? I'm suing myself? And the Minister of Justice and or Attorney General knew and did not act to correct this lie. We were betrayed and kept in ignorance to better control us. That is a statement by Angèle. Here's the evidence for those who read French, but you need only to read the upper part and the date, upper left part. Supreme Court of Canada Registry, 25th of July 2016, as evidence that we went through the Supreme Court for real, that our case is real, that everything was duly and properly presented to the court. I have several things to say about that right now, so let's put my face. All right, so Angèle followed the path of the injustice system of Quebec, ended up after the Court of Appeal, made her claim to the Supreme Court. We were now in common law. Prior to that hearing for her, which is not really a hearing, it's a file deposit, she's under the Napoleonic Code of Quebec because they have the French background. In Canada, we have common law. So this is how the Supreme Court of Canada works, common law process, which comes from the English background of the law that we have, all the way to Westminster, all the way to the entire history of Great Britain. Everything's included, everything's valid, everything was passed on to us. That's the condition for Canada to exist and be independent of Great Britain. Otherwise, we'd be them. We'd be part of their kingdom. So we filed in common law as we should. The way it works, you go to the court, you deposit your whatever, your claim. You take a copy of the fact that they've received it, right? So and now you notify the party that are the defendant, because you're the claimant. We did exactly that. 15 days later, we returned to the court saying we've got no answer from the defendant. We are sure that they're not going to be here to defend any jack shit. So we're going to present a default judgment. In that case, arise that they're not defending. We are right. Because remember, they don't have to present a defense within 30 days, but they need to signify the court that they have the intent to defend. If they're not replying to my summon of them, that means they're not coming to defend. I still have a case. I still have a claim, regardless they're coming to defend or not. So this is a default judgment. And it is for the party to prepare the judgment. Because the court doesn't necessarily have the time to hear the entire thing. Why would we debate anything? There's no defendant. So it must be the claimant's position that is right. So we're just going to read the judgment that they're seeking, and if nothing makes sense, we're going to write our own. If it makes sense, it's valid. There was no opposition. This is how it works in criminal court to this day. So Supreme Court of Canada is the same thing. We did exactly that. Dropped our file, our claim. Notify the other portion. They never showed, never answered. We didn't hear from them. Default judgment, we're gone. This is it. There's nothing else. There's no appeal. There's an impossibility of appeal. It stops right there. Why could they appeal? You didn't come for your trial, man. You can't appeal anything. The conviction's done. So we're gonna keep on going, but this is the way it's done. And lo and behold, because my judgment, or this judgment, was so serious, the grand jury was part of it, as we tagged all to Angèle. Denis' case was tagged, the grand jury was tagged, and we tagged the other case that were involved, but the grand jury itself was tagged as an entity. And remember, a grand jury is of his own right. They're technically above the Supreme Court of Canada. They're the ultimate defense against tyranny. Because the Supreme Court's not above the grand jury for sure. The grand jury can sit and look at the Supreme Court and say, okay, we're going to study you, see what we found on you. The people are the... So this is why, the next slide, and I get back to the story. Angèle identified all 9 judges of the Supreme Court of Canada associated to her previous judgment as being in conflict of interest with their association to the Federation of the Maple Syrup Producer. Now, it's so much of a big thing, the injustice system in Quebec, that somehow all 9, and this is her case, I'm reading and I'm explaining, all 9 of them judges somehow were involved in her case in prior judgment. So they were technically in a place where, well, I've already reviewed against you in the lower court by something, so now I graduated through the court system and I sit at the Supreme Court and I get your case again. So my name is somewhere in your paper. So this is... Alright, let's skip ahead. It cost $75 each for the appeal at the Supreme Court. Since we bundled everything into Angèle's case, we went there twice. Cost us $150 to actually proceed at the Supreme Court. Not a penny more. Yeah, we drove here, we stopped at wherever restaurant, we put some gas in my car. $75 for an appearance at the Supreme Court. But you need to go through all the other level. Angèle found a buyer for her property and moved out of the national state of Quebec because she was so much under pressure. They wanted her head, they wanted her land, they wanted everything. Let's make my face disappear. I forgot. Sorry. And she left. She packed up, she stole, she left. No more comment about that. Well, lo and behold, Chief Judge Beverly McLaughlin quit her job at the Supreme Court of Canada 2 weeks after receiving Angèle's injunction procedure. The reason for the resignation is not clear, but we suspect it is related to this constitutional case. Just like Sam Ahmad and Michel Després and God knows how many other in the wake of the grand jury that, had better things to do that day than, hear about us. From that day, all the procedure that we received, that's Angèle talking, were sent back to them and other court with the mention not valid coup d'etat 1968. She has not heard from them in quite some long time. This includes the Federation's attempt to initiate before the Queen's Bench in New Brunswick. I'll have more to say about that, but this is lasting for an eternity. The recording's already an hour, 39 minutes, so let's skip ahead as fast as possible. There's way, way, way more to say about that. Following the grand jury, especially in Angel's case, the grand jury's judgment was presented to the Supreme Court and received a default judgment. Let me read about a default judgment, alright? And this is in their procedure, right? A default judgment is a ruling granted by a court or judge. Default judgment arise in circumstance whereby one party to a suit has failed to perform a court order action, and subsequently that failure has not only prevented the issue from being presented before the court, but also result in the court settling the legal dispute in favor of the compliant party, in our case, us. For example, when a defendant is summoned to appear before a court in a case brought by a plaintiff but fail to respond to the court's legal order, the judge can rule for the default judgment and thereby decide the case in the plaintiff's favor. The defendant, though not present before the court, is obligated to abide by the court's ruling for the default judgment and subject to NE and all punishment requested by the court, as in Cornell's law school. So, if that is not clear, this is exactly what I said right before this slide appeared. I knew it was there, so I kind of prepared to you. The defendant doesn't show. It's over. Whatever's in the judgment is what is in the judgment. It doesn't need to go before an official sitting judge and bench. In common law, the clerk of the court, and you can verify all of this, it's in the Supreme Court of Canada status, can act as a judge in exactly these conditions. He doesn't judge the merit of the case. He doesn't judge. All he knows is that there's a failure from a party to show up for defending this case. This is where it stops. As soon as the clerk of the court in Ottawa noticed that, there's a second stamp that comes out. The first one is received at the Supreme Court of Canada. When you initiate. Each time you file something afterward, same thing. Receive. Then there's another one. Filed. It's been filed. This is it. It's over. The file is closed. Final. This is the form that the judgment was made by and on and everything. And here it is. This is our judgment that you see here. You can see, if you can read French, at the top of this, default judgment for file 37104, and is present in this paragraph here. Well, I know, no, sorry, I'm in front of it. I know. I'm reading off the screen. I'll move my face off and you can read it. And the second biggest paragraph, right in the middle of the first page, the present judgment by default is emitted by the Supreme Court of Canada. So this is what we got as a default judgment. Yeah, no judge from the Supreme Court has ever read into it. They had no say. And it's default, right here. The judgment was delivered to CSST in December 2015, Office of the CEO. Now we're talking about the grand jury again, not the default judgment for the Supreme Court. The judgment was delivered to the Ministry of Labor, Ministry of Justice of Quebec, and I'm going to come back to this one. I got a funny one. The judgment was sent to the Quebec Bar Association, so all 31,000 whatever lawyer in Quebec were informed. Judgment was sent to the Federation of Maple Syrup, Maple Syrup Producer, of course. Judgment was sent to some of the corporation now listed as criminal organization, and the judgment was delivered to the RCMP on December 18th, 2018, which is a significant date. You will notice that there's a 3 years gap here. I'm just going to come back to 30 days after the judgment of the grand jury. We did just a little side joke here. Well, it's nothing about what I'm saying is a joke, but here's a little funny story. We go to the Ministry of Labor, and Garda World's down there at the bottom, and they know us because we've been there over and over and over. But there's one place we've never been, and it's at the Ministry of Justice. So we don't really know our way there. So we get to the parking lot in the morning. We wait for the employee to arrive, guard the world first. They would turn on the light and whatever they do. And now start pouring in the regular employee that works in this building. So we get to the door, and of course, lo and behold, they've seen us. There's 5 or 6 of us, including Denis, myself, Angèle, and a couple more. And Angèle is a very small lady, so at the beginning she's kind of in front, right? And because she's the voice of us being there and delivering, right? And I'm right next to her, and no, I'm behind Denis, and I'm pushing the wheelchair. That's true. Um, so Garda World is there with their arms crossed, and you're not coming in here, blah blah blah, because they know us. So I'm just looking across the hall, and I see all the employees that are working in this building. They're coming in from the other side. So I tap at Angèle's shoulder. Come behind. Let the man be in front. So everybody else steps in front of us too. I dragged her around the building real quick and say, "Look, you've got all the paperwork ready?" She says, "Of course. My paperwork and my my recorder is ready." So I said to her, "Let's sneak behind the employee. See, they're all coming in from the other side." So we sneak behind the employee. We get to the 7th floor, just like that. And we drop the grand jury's judgment right on the desk of the Ministry of Justice. So they can't say that they have not received it. All right, so let's skip now to RCMP's turn. It's a little less spectacular, but I have a little more detail on December 18, 2018. This is what the response from the RCMP was for dropping the grand jury's judgment. The triage group of the National Division of the Royal Canadian Mounted Police received your document that you deposit at our headquarters in Ottawa. Yeah, right. Yeah, I know I was there. After reviewing the information you provided, it was determined that it did not meet the threshold to initiate a criminal investigation under the mandate of the National Division. The mandate of the National Division is to conduct investigation into such cases that undermine Canada's political, economic, and social integrity, including but not limited to national and international corruption, war crime, and crime against the human race. As noted above, you can contact a legal representative to help you with your civil complaints. Well, first of all, it was a grand jury. It discovered 110 criminal charges against pretty much the entire national state of Quebec. And the RCMP has told us a few weeks prior to that over the phone that, yeah, Mrs. Prince, which is Angèle, we have no jurisdiction in Quebec. Why? Because, yeah, they're not part of Canada, legally, lawfully, and constitutionally. So the RCMP is not there. But what this does not say, and I'll tell you because I want to keep all of this short and sweet, is that this RCMP is basically giving us carte blanche en bon français. They say we will not interfere with what you're doing. And especially we're not going to hold it against you guys which are doing that. And remember, at this point in 2018, we've been everywhere. Everywhere we've been. There's not an office we have not spared that we went and shared that, really. From the Bar Association to private lawyer, at that point I think I have met probably with 20 or 30 lawyers and the rest of them, and I've been to court over and over and over, and with Angèle as well. So we're well known at this point. Right, so if you want to take a break, there's gonna come a point, where it concerns you directly. And this point is right now. What have we learned from the grand jury process? And how is it becoming the story of us all? Well, I already told you a lot of hints. Quebec is illegal, unlawful, illegitimate, and unconstitutional. And on top, it's a criminal organization. This is where it becomes the story of you, the story of us, the story of we. And it is very important to understand that they've done no less than a coup d'etat. You don't know constitutional monarchy. Even what's in the paper is not the right thing. Listen to this. It's quite simple. In 1931, yes, the year 1931, Canada was given its independence from the British Empire. We were never part of the United Kingdom. We were part of the colony of the British Empire. It's a different thing than the United Kingdom. Totally separated in law and custom and in everything. When the empire fell, and nobody could provide enough troop to the empire to keep the colony, each and every one of them was given his full independence under one condition. You've got to set forward a system that is similar to Westminster's parliament system. Because remember, there's two things. There's the empire, which is governed by a small group of people which are not elected and they tell everyone else what to do. And there's the Westminster system, which is the parliamentary system of Great Britain itself, which is a member of the empire, as any other. They just happen to be the overlord of the empire, but they're a member of it. The empire is disbanded. You've got your independence. You're on your own. Put forward a Westminster system. That's it. Canada did not do that. Great Britain stopped sending the letter patent to name on the behalf of the sovereign the Governor General that's in 1867 BNA Act. And from that point on, free for all was called on. They've modified that BNA Act to the point that in 1982 they've added on the Charter of Freedom and Right, and they made a little ceremony and pretended that everything was all right, ladies and gentlemen. So, in very few words, in 1931 we were sold. The then Prime Minister of Canada didn't dare tell the people of Canada, well, all of a sudden, ladies and gentlemen, we got to re-establish our new royalty because we've been ditched by the royalty of Great Britain because we are no longer part of the empire. And it's so true that I'm going to show you in one picture that there was a coup d'etat made in several steps. There are some major ones. 1931 is free for all, and in 1968 was done again, and to pull out Quebec of I got the exact date, 31st December, to pull out Quebec of the Confederation of Canada. Then they set up pawns in Ottawa to control the narrative and fool you all, but they were all we were already sold by that point. So that was I was saying earlier. Unless you're very, very old, you don't know what constitutional monarchy is. I'm gonna pull the camera here. It's gonna be blurry and all that shit because of the. Actually, I'm gonna raise the book instead. See what if I move the camera, it's gonna be a mess. All right, I'm gonna show you this picture here. Which is what happened in 1982. I'm gonna point out the signature that is here, Elizabeth II. I'm going to point out also, which is not written here, the law of contracts. When you put your name down on a dotted line down the contract in black or blue with proper pen, you're signing for everything that's above. Anything that's below does not apply because you didn't read the rest, you didn't agree to that, you agreed to what's above. So think about that next time you receive we've modified the condition of your contract. Really? I never signed for this. I signed for the original condition. Anything you say, you cannot alter without making the contract null and void because it affects the original text for which I signed. We're out of business now. I owe you nothing. You've changed the contract. Bye. I'm reading you. You notice the signature? Elizabeth II, by the grace of God of the United Kingdom, Canada, and our other realm and territory, Queen, head of the Commonwealth, defender of the faith, to all to whom these present shall come, or whom the same may in any way concern, greeting. She signed that. And then there's a proclamation below stating a whole bunch of shit, which I'm not going to read to you, which is signed by the Registrar General of Canada, who is that guy, and the Prime Minister of Canada. Yeah, really, who is that guy as well? And that would be when the Constitution would be repatriated officially. When with this, there was this proclamation. Well, Elizabeth didn't sign jack shit except what I've read. Anything that comes below. In fact, absolutely nothing but a show happened on 17th of April 1982 to keep on pretending and fool you that, there may be some problem with Canada because, yeah, they're asshole in Ottawa. Well, we agree they're asshole in Ottawa, but they're certainly not busy keeping the constitutional monarchy well and alive. They've made hundreds of modifications to the Constitution of Canada. They made thousands of infractions to the Constitution of Canada. It's beyond word. I could spend 1,000 years telling, what a million people how they've screwed that country. But we've learned. We've learned a lot from the grand jury. And we've learned the most important part. There was a coup d'etat. Nothing short. They don't belong there. Anything, everything, all the things that they've said and done since 1931 is null and void. Everything. Every license, every project, every debt, every interest rate modification, every name it, everything that happened in Canada. This is by the power of the grand jury, and this is where we're learning from the grand jury. Lee Center Spooner said and wrote that the only true power in a democratic society is to put a collar to the government. How do you do that? You restrain them. You hold them accountable. How do you do that? A grand jury of the people. And the sole power is to judge the government? No, the sole power is nullification. Every jury of the people, the owner of the land, the supreme authority, can nullify what government says. They cannot do law on its own that will apply. Oh, we're going to do a law. We're greater than everyone. And no, you elect your government like you always do. If these assholes don't listen to you and don't do as you say, you take their law and strike it down. And that's it. No more said. Even if the law is 100 years old. Well, your law was invalid 100 years old. 100 years ago. Still invalid to this day. So this is what we learned. And why is it this way? Magna Carta, the year is 1215, the Lord of Good, the year of grace, 1215. Many significant documents are available that help us to understand the history of Canada. If in doubt about the authenticity of the validity of the Magna Carta and Bill of Rights, the Toburn judgment has clearly described these as constitutional status, which are immune from implied repeal. This means that no legislation subsequently enacted can in any way alter their legal efficiency. Remember, Magna Carta 1215 predates Parliament and therefore it has no authority to abrogate or repeal it. Of course, you cannot abrogate or repeal a document written by someone else. You cannot. You didn't write it. You can't not alter it in any way, shape, or form. That's his document. It was perfect before you start fiddling with it, playing with it. Why did you put mud on the perfect anyway? The Act of Union. Upper and Lower Canada merge into United Canada, Canada East, and Canada West. And here you see the organization chart. I'm gonna remove my face because, yeah. The Act of Union was passed by the British Parliament in July 1840 and proclaimed 10th February 1841. It united the colony of Upper Canada and Lower Canada under one government, creating the province of Canada. This is why province cannot emancipate. This is why they cannot leave at all. They are not autonomous in any way, shape, or form, or independent from the entity that created them, Westminster. They cannot ignore that. They're not free from that. The Quebec Resolution of October 1864. All right, so the Constitution, the BNA Act of 1867, was indeed. The Quebec Resolution, also known as the 72 Resolution, was a group of statements written at the Quebec Conference of 1864, which laid out the framework for the Canadian Constitution. And we were supposed to have the PDF here. So, just short, you can see them here. Even though there were what we could consider the bourgeoisie, the mid elite class, there were Canadian people, regular, the people that were living in Canada in 1864. There was not really an upper class to say in those days. Yeah, there was some kind of organized group of merchants and stuff like that. But overall, they were residents of Canada and they were living in the same exact overall misery as everyone else in Canada. It was not really a modern nation in 1864. So it was written by us and not by them. It didn't came from the Parliament of the Empire, which once again is not Westminster. It came from us. So here's the kind of final nail in Canada in 1982. The Constitution was never properly signed, and the reason is not what we think. They fell on April 17, 1982, then again at Meech Lake, and fell again in Charlottetown, because they were trying to involve the province to sign the Constitution to get an agreement. Well, I got bad news for you all. We don't need, as Canada, the agreement of the province. This is Canada. This is one. That's it. You didn't sign to become part of Canada. Canada was created, then divided into province. Divided in British Columbia, Alberta, Saskatchewan, and the rest of it. Not the other way around. Alberta didn't exist as anything before we decreed it as Canada back then. That, not me, we is Canada, put a decree or an enactment saying, okay, this is now the province of Canada. This is it. This is Alberta. It was not, hello, we're Alberta, can we join the federation? No. It's a confederation. The division comes from the top. That's how it was created. It can never, ever, in any way, emancipate. So the whole process failed because the national state of Quebec was already de facto since 1968 at the very least. And this is why exactly what I just said a moment earlier. It didn't fail those conference for the lack of signature of province. Because even if they had them all, Quebec was already illegal. Even if they had signed that, the very government of René Lévesque, who would have signed that, it would have been illegal because they had no right themselves to sign that. They had no right to claim themselves the government of the legislature of the province of Quebec because they were already the national state of Quebec in 1982. And 1982 happened because they had the Quebec Bar Association lawyer puppet, Trudeau father, in Ottawa at the time. And they had Jean Chrétien, which was another puppet from the Quebec Bar Association, same as Mulroney, and same as who else then? Jean Charest, and damn it, there are so many that I forget their name, right? But yeah, Quebec Bar Association. The Constitution Act 1982 contains the Canadian Charter of Right and Freedom and other provision, including the procedure of amending the Constitution of Canada. I got bad news for you. The government in 1982 was illegally formed. The Charter of Right of Freedom has no force or effect, even though some of the things that are part of it are very intelligent. We cannot take this Charter of Freedom and make it say anything that would modify the BNA Act of 1867. It cannot be done. It was done by the Parliament of the British Empire and sent to us. That's where it became law, the BNA Act. So that's the only version that's valid. Nothing that the government of Canada or the province can say can modify the original. And it's so true, ladies and gentlemen. that if you look on the Parliament of Westminster and you look there for the BNA Act, it is the same as the original. The one that was after receiving the 72 resolution from Quebec City, they turned it into the BNA Act. Well, that version they wrote themselves is the legal, lawful, and legitimate Constitution of Canada. This is it. Everything they've modified, including the charter, is of no force or effect. It was introduced by a government that was illegal himself. It had no right to be there. So, we've been learning so far with the grand jury the Constitution that wasn't. In short, in 1931, when the status of Westminster happened, we should have named our king or queen. It wasn't. It didn't happen. The government was rendered illegal from that point on. In 1968, officially, there was nothing left anyway. Everything changed form by that point. Quebec indeed separated from Canada by splitting entirely from the Constitution. So what I'm not going to read this one that's in the background because that's part of the Charters of Rights and Freedom. And so just want to point out that, they cannot introduce that law, the amendment or whatever of the Charter of Rights and Freedom because the assembly that wrote it is illegal. So therefore, the signature of the province is irrelevant. And if at this point any province would try to separate, they would make a deal with the fake corporation of Canada that cannot allow that in any way, shape, or form. And even if they did surrender anything that belongs to Canada, this is not valid because their government is not valid, their courts are not valid, they're not abiding by the Constitution whatsoever. Every of their license and act are invalid. Everything is invalid because the Constitution was not respected in as it was written from 1931 on. So this picture that I'm showing you is the one related that I've shown in my book just a few minutes ago. This is exactly the moment where they actually sign the said constitution, but Elizabeth II, which is the lady in the middle, is signing the proclamation that I've read to you earlier, the salute thing. And you see the Quebec Bar Association that are all happy and smiling in the form of Mr. Trudeau that is there on the left of the picture. And here's, I didn't remember it was there, but here's the picture from my book. Right there, you can see in the red circle in the middle. If you cannot zoom, I'm sorry you cannot read the text, but everything is official. I have had it in my book earlier as an example. I forgot it was here. Otherwise, I would just waited. And you can see Elizabeth II signed the little greeting that was on top, and the proclamation is below, signed by God knows who. And no power. They had no power to do that. Zero. They were illegal. It says Constitution Act 1867, Part 7, General Primacy of the Constitution. By the way, that's in the Charter of Right and Freedom. Even though it has no value, like I mentioned, there are some good stuff in it. Here's one of them. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provision of the Constitution is, to the extent of the inconsistency, of no force and effect. So, in clear, anything that goes against the Constitution is invalid. The Constitution of Canada include A. The Canada Act 1982. The Act and order refer to the schedule, and any amendment in any act or order refer in paragraph B, blah, blah, blah. Alright, so this is not valid, but it's still valid, if you understand me. It's still true. Everything that's word there in part 1 of those two little those two paragraphs, but the text that writes it down is invalid because it's in the Charter of Right and Freedom, which is invalid, but it's still true. That's the fun part. Here's another same category. It's not valid as a law, but it's still true. Application of this charter. This charter applies A. to the Parliament and Government of Canada in respect of all matters within the authority of Parliament, including all matter related to the Yukon and Northwest Territory. And remember those two words, eh? Including all matters relating to the Yukon and Northwest Territory. And B, to the legislature and government of each province. We're missing a word here, but that's how it ends. Yeah, we're missing a word, but that's it. So, in clear, to the people of Canada, you're often. Let me wait on. Put the camera for that one. I know my rights. Yeah. I don't give a fuck about rights. I have freedom. And I know that everything about the government is illegal. Okay, because everyone else is kind of slow to understand that, I kind of have to pretend that I'm a law-abiding citizen and blah blah blah, and I don't spit too much on it. Oh, yeah. But I happen to also understand the law, which says this charter, well, the Constitution, and everything that comes from it, every license, every law, every officer, every blah blah blah, are all under the Constitution, supposedly. Well, it applies to Parliament and Government of Canada and legislature and government of each province. Neither of those. So you're telling me no law applies to me. Because that's the truth. Because it's in the Constitution. So yeah, nothing of their bullshit applies to me. I got one law only to respect as a human being. Do no harm. As long as I do no harm, nobody has a claim against me, and I didn't do harm willingly to someone. I didn't went and steal or spit on your dog or whatever. I didn't do any harm. So leave me in peace and go do your stupidity of pretending that everyone's under the law. I'm not under the law. I'm above the fucking law. I am the law. It says it here. All the law applies to them. It's not because I made it, in the corner of my foreign field. It's right there in the Constitution of Canada, And here, again, same category, it's still true. It doesn't have to be written anywhere. And it doesn't enact it as true because they've written it. It's still true. Even if we throw apart the Charter of freedom and of rights and freedom, it's still true. They can't do anything to amend any of what I'm about to say, and there's plenty more than that. I'm gonna read those just to keep it simple. I'm gonna throw my face off this. Yeah. Fundamental freedom. Everyone has the fundamental freedom. A. Freedom of conscience and religion. Freedom of thought, belief, opinion, expression, including the freedom of the press and other media of communication, just like I'm using now. Freedom of peaceful assembly and freedom of association, which is the most important of all. Right? Put back my camera. Even if they wrote the most beautiful text, the government's legal, everything, they wrote the text, everybody must abide by the rule of the government. I still have the freedom of association. I want nothing to do with your club, whatever it is. Leave me the fuck alone. I owe you nothing. You ask nothing of me. I ask nothing of you. This is it. It works between individual. It works between me and any corporate body. It works between me and government. It's still true. And even if they ripped it apart, even if they've never wrote it, it'd still be true. It would still be true. I want nothing to do with you. Have a nice day. Nobody can take that away. That is freedom. And it's in their text. Yet, the text is invalid. But it's still true. Rule of government apply only to you. I'm not part of you. Leave me the fuck alone. Oh, what does it do for the tax law? What do you think? Freedom of association. Canada Revenue Agency. Who are you? Government? Fake government? Illegal government? What legal base are you sitting on, CRA? None. Freedom of association, nonetheless. Even if you did add everything was legal, but it's not. So, Canada Revenue Agency, have a nice day. Nothing to do with you. Not paying, not filing, not fuck off. Not claiming. In the case of Paul Leblanc, this is a funny one. Is this court constitutional? At one point, we were going to court after court after court, and the black box here that you see on, I'm gonna turn, but the black box that you see here is the audio of that. I don't have it, but it would be in French anyway, so it doesn't matter. Here's what it says, right? In the case of Paul Leblanc, we were in court every week. Following the grand jury, during the grand jury, almost. Anyway, a judge of the Quebec Superior Court, Jean-François Michaud, made a startling admission. That is fact beyond fact, ladies and gentlemen. We asked him, that's Paul Leblanc, but it was under my advice, we asked him to prove that the Quebec legislature, the National Assembly, and the legal system was legitimate, lawful, and constitutional. The judge replied that he was not going to be able to prove it to us, and that nobody in this courthouse would be able to prove it. He said to ask the grand jury about the constitutional and lawful issue. And you can write to him to the address that you see there and ask him about that. If you want. Like I said, everything is public in our case. So there's no anyway, and everything was done before I know Republic. Michel Lebrun, the 1968 coup d'etat. Michel Lebrun, a former Quebec Bar Association lawyer, attended the grand jury as a witness and talked about what happened in 1968. The Legislative Council of the province of Quebec was illegally dissolved. This was unconstitutional. The disbanding of this council, in fact, created 11 infractions contrary to the Constitution. This is when Quebec officially stop being a legal, lawful, and constitutional part of Canada. That was December 31st, 1968. That was a corporate coup d'etat. That was the last, not the last, but one of the big milestones of the coup d'etat. The Legislative Council was put in place to prevent abuse of the Constitution by the Executive Assembly, the National Assembly. The Executive Assembly now makes law that better serve themselves than the people of Quebec without any legal, lawful, nor constitutional ground to stand on. 1968 coup d'etat. What is a coup d'etat? A sudden, decisive exercise of force in politics, especially the violent overthrow or alteration of an existing government by a small group, or the sudden, forcible overthrow of a ruler government, sometimes with violence, by a small group of people already having some political or military authority. That is exactly what happened to our country in 1968. They threw out the Legislative Council, and they said, we make the rule from now on, but that was over. That is when Quebec became a province in rebellion. But on paper, it's not at all a province of Canada anymore. It's the national state of Quebec, and they have various deal when a new issue arise, and they deal everything in between themselves. And of course, they give to their little friend of the regime each time they do any project on your back. Each time. This picture won't say too much about it. The grand jury's procedure, which is this is the evidence for you, really happened from one end to the other. We didn't miss anything. It was not so greatly organized, to be honest. But we did pull it out. All the 70 or 80 hours I lost count of the procedure themselves, the hearing, are all in French. So normally I would invite you to come to my YouTube channel. Maybe the AI could do a somewhat good translation, but it's going to be 60 hours of edX, so I don't want to invite you at all. Right? You can go if you want, if you still want. All right, so Quebec does not have a unilateral right of secession under the Constitution of Canada. However, a clear majority voting on a clear question on Quebec's secession would entail a constitutional obligation to negotiate with the other player in the Canadian Federation. Moreover, under international law, Quebec does not have a unilateral right to secession. This is why other province trying to secede is a complete stupidity, because that also apply 100% to them. The province are a creation of Canada. Canada is not a creation of sovereign province in every way, shape, or form. But remember, no government is legal in Canada since 1931. So anyone trying to split a province, not only is it really, really in trouble already because they legally cannot be there, if they take away Canada on top, that's a big, 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 big problem for them. How could the province of Quebec be able in 1968 to change the British North America Act, since the Supreme Court cite the following? Thirdly, the British Parliament cannot make a change to the Constitution of Canada at the sole request of a Canadian province. Some attempts have been made by the province in this direction, but without success. The first, which date back to 1868, emanated from the province that was not satisfied. Supreme Court of Canada, August 1998. Even though the Supreme Court was illegal in 1998, that is still true, what they just said there. And I just pointed the fact that 1868 is 1 year after 1867, which is the year that Canada officially received the BNA Act. Right? Remember, this was written by the people, and already a province was unhappy a year after, trying to alter what the people have decided in the 72 resolution a few years prior. So they've tried ever since to destroy the people. And BNA Act was written by the people, for the people. De facto. Here's the form of government that's currently claiming that they're the government legally of Canada, but it's not. In one word, it means in fact, indeed, or actually. This phrase is used to characterize an officer, a government, a past action, or a state of affair which exists actually and must be accepted for all practical purpose, but which is illegal or illegitimate. In this sense, this is a contrary of de jure, which means rightful, legitimate, just, or constitutional. Thus, an officer, king, or government de facto is one who is in actual possession of the office or supreme power, but by usurpation, or in respect, or versus in respect to lawful title, while an officer, king, or governor de jure is one who has just claim and rightful title to the office or power, but who has never had plenary possession of the same, or is not now in actual possession. De jure, the meaning of de jure, you would think it's the exact opposite of the definition of de facto, but let me read that. De jure, of right, legitimate, lawful, by right and just title. In this sense, it is the contrary of de facto. It may also be contrasted with the gratia, in which case it means as matter of right, and as de gratia means by grace or favor. Again, it may be contrasted with de equitate, here meaning by law, as the latter means by equity. So Canada is a registered corporation. So is Quebec. So is every other province. That is, my friend, ladies and gentlemen, and everybody else that hates me, is illegal. Canada is a kingdom. It belongs to its people. We could eventually, each and every one of us that's alive, born in this land, receive a portion of the title by one share, let's say, of Canada, but it's irrelevant. We get it because it belongs to us. I was born here. You were born here. We were born here. This is where it becomes the story of we. This is not the story of Denis Paiement or Angèle Prince or even me. Especially not me. I'm just the mouth that's speaking for those people that cannot defend themselves. And for you that will be listening to this that don't know about all of this. So here's a case that could be studied before the grand jury. We did touch it in the 2015, but we had other matter at hands, and we had enough to prove the coup d'etat. But here's the entire deal. Canada is a corporation since the coup d'etat of 1968 made by the national state of Quebec. This goes against the judgment of the Supreme Court of Canada related to the secession of Quebec. It is registered as a corporation with the U.S. Security and Exchange Commission. So yeah, as evidence, you can see it here. You can make your own research. But yeah, if a corporation is registered into another country, it's a corporation of that country, so it's not a corporation of our country. You know, if we wanted to register Canada, we make the Registry of Canada, and the first to register is obviously the government of Canada because it belongs to us, and it should state that way, not registered into a foreign entity. So yeah, here's the proof that Canada is not a country, just a corporation. You know, simple Edgar search on the sec.gov that blah 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 there, and you get the answer. So, learning from the grand jury process still, Parliament of Canada. I'll let you read this. I'll briefly, and then I'll point at number 2. Parliament shall not determine or be dissolved by the demise of the crown, and notwithstanding the demise shall continue and may meet and convene and sit and proceed and act in the same manner as if the demise has never happened. This is written, ladies and gentlemen, because the crown in 1931 was demised. There is no crown since. We have a viceroy, call it however you want, seated in the governor general's seat, which is just a seat holder, because we all know now that the governor general is just a clown and a puppet that is now named by the supposedly prime minister, which act as the head of state. Well, I got bad news for you. And the Constitution of Canada, even if you made the devolution, let me read devolution, the transfer or delegation of power to a lower level, especially by central government or local or regional administration. So that's illegal. Canada is a monarchy, a constitutional monarchy. The head of state is the king or queen. Anybody else trying to claim the crown is indeed a clown and cannot act legally because, are you the king or queen, Mr. Prime Minister? By the way, I got a few things to say about that. Your title of Prime Minister does not exist in law anywhere. So, you are a legislator, right? Okay, so you're below the Majesty, you're below the Governor General, you're below the Senate, and technically speaking, you're also below all Lieutenant Governor, which the account is 10. Because they're all there to prevent you from writing any law which is unconstitutional or and against His Majesty in any way, shape, or form, especially usurping the crown for yourself. So yeah, you the Prime Minister of the legal, lawful, and legitimate government of Canada? No, right? Because I don't ask questions for which I don't have the answers. So you take a seat and you shut your mouth. Thank you. Because we have found who is Queen Elizabeth. Because we've learned everything to this point that and more and much more, we took a chance, we took a seat, we convened, and we asked ourselves, who is the head of state of Canada legally, lawfully, constitutionally? And we agree, oh well, that must be Queen Elizabeth. Well, yeah, okay, so let's ask her the question directly. You know, she'd probably be in the best position to answer, so here's what we've done. We've sent a royal claim of right to Westminster Parliament and one copy to Buckingham Palace. We've received no response. The constitutional case was also the freedom of association. was also sent to Westminster and Buckingham Palace. The office replied that the case should be addressed to the de facto Governor General of Canada, sending us back to the accused. Remember, because at this point we're through the Supreme Court and we have discovered the coup d'etat. So, yeah, the Governor General, named by the Parliament in Ottawa, which is illegal since 1968. Yeah, these guys? Well, no, thank you. We've already done that. Been there. So the article 2 is what I've just read before, just a special note I'll read here. This law has no legal or lawful validity. You notice the date, it's Parliament Act of 1985, pardon me, P1 Article 2. That was written by an assembly that was not legal to be as Government of Canada. Yes, yes, okay. So what they say is illegal. Yes, yes, okay. Have a nice day. I keep on pressing previous. All right. Here's 2 pennies, 2 1 cent coin. And yeah, who is Queen Elizabeth? The one on the right with the crown? Or the one on the left without a crown? Yeah. And if you notice on the right, it says 1932, 2002. So there's an opening and a closing date. If there's a closing date, there's a closing date. That's the end of it. This is when it happened, and yeah, it doesn't happen anymore from now on. So we're really wondering who is Queen Elizabeth. And notice that we've got the penny on the right that is now enlarged. We see both sides, and we see that this one was minted in 2003. So, yeah, Queen of Canada 1952 to 2002, and minted in 2003. That was the last time she had a crown. You can look at the $20 bill. It's also obvious. So, what do you do once you find that your country was sold before you were born and that you were sold on top of it to guarantee the continuity of bad action and abuse and lies and nothing is as it seems? Everything is a joke, everything's a fraud. Well, there's two paths to go. Actually, there's three, but one is completely stupid because now you've been discovered. You keep on going. Or worse, you join the coup d'etat and you collaborate to make it still going. If I know that the government is illegal, don't worry. And I've warned them. The Quebec Bar Association knows. The judges know. I've been there. I've told them several times by myself. It's in French. Everything's recorded. Everything's on my channel. Everything is public. Everything is true. There's the path of you do nothing, which is not as bad as the first one, but you have no justification to keep on doing what those clowns are telling you to do, and abiding by everything that they do is okay because now they're the government. They can send billions of our dollars into a foreign country to buy munition from the orange men down south, and yeah, everything is fine. No, why do we have people that live on the street? And then there's the third one, which nobody except for me and a few others over the time, which came and went. You can take it back. It's yours to begin with. They took it away from you. Whatever they did with it was wrong. It is yours no matter what. I'll give you an example. My car is parked in my driveway, and I wake up in the morning and I got my keys in my hands. I'm going down my alley. Where the fuck is my car? I see the car go by. Hey, wait, that's my car. You know, there's a thief that took it. A few days later, you used to walk with your keys in the pocket, crying about your car. Right there, it's parked. You know, he took it there. Joyride, whatever. You do. What do you care? You press the button, you unlock the door. Here you go. You put in the contact, and there you go. Yes, there's wire underneath. What so what? You didn't do anything. You notice after driving it for half a corner, yeah, there's a brand new radio. Where does that come from? Well, do I care? This is my car. Whatever he did with it was wrong in the first place. So this radio is now part of the car. It's mine. I mean, maybe he stole it somewhere else, but me, I mean, where's my old radio? Here's the new one. This is mine. No cop's gonna come behind you. Hey, you've stolen a car. I got the keys, man. Registry, driver's license. What the fuck do you want from me? You're the government. Go about your day. Want nothing to do with you. Freedom of association. Have a nice day. This applies, that freedom of association, especially today in 2026. It was true in 2015 when we discovered it, but it's even more true today. Freedom of association have always applied, no matter if it's written or not, no matter if they respect it or not. I want nothing to do with you. That is where it stops. And if you do grand jury, because government is completely delinquent, they're criminal. At any point, anytime, the people can sit and say, you wrote that as government, legal or not. Same applies. Same is true. Written or not, it's true. We want nothing to do with that. Strike down. But you cannot do it on your own. You need to prove your case. And you need to give a chance to the opposition, the government, to also prove its case. They may be right. I mean, they survive so long because once in a while they do the right thing. They're not all stupid, and especially the regular employee, which are not the political class. I mean, you call somewhere, you ask for an information, the guy or gal that works there, she does her best to serve you as a public servant. She knows nothing about that, just like you didn't. So what do? You take it back, goddammit. It was ours, so we did. We seriously did. Alright? This is the part you won't like, but it is still fact. Learning from the grand jury, creating a de jure society. Since everything is de facto, let's create a de jure society. We form a not-for-profit society in 2017 and send the royal claim of right to Westminster and Buckingham Palace. I created this society. It is mine. The SRPC, as his name, in French, Société Royale Publique du Canada, or in English, Royal Public Society of Canada, forms the official, lawful, constitutional government of Canada by consent and authorization of the people of Canada under the Great Seal of Canada by the Canada Act 1982, Chapter 11 UK, and all other legal positions of the Government of Canada of lower rank are to be filled according to the criteria of the function in question based on the need of the people of Canada and, of course, the Constitution, like I just mentioned right above. The monarchy of Canada or sovereign of Canada, as well as the constitutional monarchy of Canada, as not legally, lawfully, or constitutionally designated an official successor in 1931, based or by hereditary inheritance of royal right, royal lineage of the United Kingdom of Great Britain and Scotland. They could not. Nobody that is not Canadian can claim to be the king or queen of Canada. You need to be born here or otherwise, citizen. Excerpt from the royal claim of right in question that I was just mentioning. We did that. Whereas good government required that public policy be based on the supreme law of the Constitution of Canada, which render inoperative any contrary provision. Whereas the people of Canada as whole, superior in fact as well as in law, is and remain the owner beneficiary of the sovereign of Canada, delegated in trust through the Canada Act 1982 as Royal Sovereign of Canada or King of Canada, all constituting the nation of Canada. Whereas the Royal Sovereign of Canada and or King of Canada is a public servant, and all federal, provincial, territorial delegated appointed by him to ensure public order and good governance of Canada are subject to the Constitution of Canada. Notice here that there's not the word population, citizen, or anything in that lineage. It applies to the government. Keep on going. Whereas this royal claim of right does not constitute a rebellion, a revolt, or a revolutionary, or nor an awfully unlawful or criminal opposition. This act does not constitute in any way the revocation of the royal right to the rightful claimant. This act does not constitute an infringement on the previous royal person, sorry about that, nor does it infringe on any act resulting from a prohibited or criminal act. The present royal right public act is presented with a view of redressing wrong for public order and good governance. So remember, this was sent to Buckingham Palace as a royal claim of right, because we thought that, yeah, they were the previous crown of Canada. I don't want to get into monarchy of Great Britain more than anything. I will keep on reading what's here, but they also have a big problem, bigger than ours, I believe. All right, thank you for your patience. We're almost at the end here. Elizabeth II, previous queen of hereditary right or legitimate Canada sovereign, or any other person having right in the order of succession, has not expressed any desire or wish to resume the role of royal sovereign of Canada, entrusted by the people after the Official Devolution Act of Parliament 1985, subsequent to the repatriation of the Constitution of Canada Act 1982 to this day. This absence alone justified the present claim of royal law. De jure, political legitimacy reinforced the legal validity for Denny First in regard to the actual royal claim of right of the title and function of King of Canada. The 20 year of an acquired right in relation to the independence of Canada have passed, this undoubtedly removing any right that would have been acquired by hereditary or past legitimacy. So, told you, you take it back. Well, we did. And in 2017, on the 4th of April, we did that. I know, I was there. So, very simply, and that was published in the by Ronald McGregor in a paper that I forgot the name in 2017. Please forgive me because it's 9 years ago at this point. Sorry. We're yeah, there's a few things that a few names that I forgot here and there. So here's what happened. The king swore his oath to the Constitution on April 4th, 2017 in the town hall of the municipality of Lamacasa au Canada. It's in Quebec, the national state of Quebec. And that's what it says in the little text down at the bottom that you cannot see all. And you see me in the same costume as the beginning of this presentation. So yeah, we claimed it, we made it through. We're almost at the end here, so we have founded Canada. There's a ton load more to say after the end of this presentation because it was made in 2019. It goes and cover until roughly that date, excluding the event of why it was written. There's way, way, way more that you need to know. But if you got one thing to remember through all of this, where was I? Sorry. It's a royal claim of right. It's learning from the grand jury process. All the power and everything that has been done has been notarized. Everything has been notarized. I'm not using it rightfully. Everything was an authentic act before a notary public. That's how I wanted to say it. That's what it was. I didn't want to have to do any of that. I was capable of doing all of that. It was sensible, it was intelligent, it was the logic. Everything is based on fact. Nothing of what you've heard is my opinion in any way, shape, or form. Nothing was made up by me. Everything is true, proven. Everything has been before a court of the people of Canada. We've broke our ass doing that. We've lost people to the battle. People were too sick to keep on going. It was a painful process. I'm not promising anything to anyone. But I promise you this: if you do nothing, you get nothing. The truth is, grand jury can be organized by everyone, everywhere. There's a certain and very small amount of real rule surrounding it. But the truth is, they are the upper authority of man on this planet and above government, and they are the one that who are responsible for stopping them. You don't use grand jury against your neighbor because your fence is on your side more than on his. You use grand jury to control government and put an end to general insanity, a corporation and all that shit exploiting without we the people having anything to say. Oh, fight us in court. Yeah, the corrupted court of the government that gives you your license and they collect taxes for you from you, right? Those guys that are illegal for over 100 years now at this point. Well, close to it, in 5 years, 95 years now. So I didn't want to have to do that. It is up to you to organize it. It is what it is. Grand jury have the freedom of association. It's an association of its own right. It is above everything else. If you do organize a grand jury, try not to pick 23 of your buddies. Because then we can contest your grand jury that, yeah, you knew these people before. In a jury, you normally mostly don't know who the judges are. Yes, they could be, two people from Calgary or something like that. But I mean, generally speaking, you don't need to know them. This is why in our grand jury we've used a draw. 100 people signed for it. Put your name in the hat. We picked up 23. This is you. Do I know you? No. Do I know you to this day after? No. Thank you for your service. So this is the last excerpt from the Royal Claim of Right. I'm gonna read it, even though you've had a lot already. So I swear that all that is represented in the present claim does not constitute normality. It is made by extraordinary recourse as a matter of urgency in assistance to a person in danger under the law of the Good Samaritan Act, in order to defend the people and the nation of Canada through the application of the Canada Act 1982. I swear I have no personal interest in doing so, that I act in good faith in order to redress wrongdoing. I swear the truth of all fact alleged to the best of my knowledge in order to justify this claim. I swear allegiance to the Canada Act 1982 I signed freely and voluntarily by Denis Pema, who by that process became what you're gonna see here. We have crowned a King of Canada very officially on July 1st, 2017, in front of Parliament in Ottawa at 0900, as this evidence show before the AI was invented and made public. That day, we arrived there in Ottawa. We were first there. It was a little rainy. As you can see, the streets are wet. They all fenced up the parliament for whatever event they had planned that day, which has nothing to do with us. They saw us coming. Cops were everywhere. They opened the gate that you see there. And we've made our ceremony, and it is duly published on my YouTube channel since I don't know when I put it online, but it's there and it exists and it's not a joke. So we're gonna close this. Yes, Canada as a king. Yes, Canada as a monarchy. It's a little touchy these days because now we're in 2026, like I mentioned. That picture is in 2017. Lots of water has came under the bridge since then, so things are a little different, but it's not part of this presentation. I'm gonna stop here by finishing the pages that I have. The Right Thing to Do was written in 1937 by Russell Roger Smith. It consists of only this. The next step is an interprovincial conference where an agreement can be reached upon the power to be conferred to the central government and the power to be retained by the province. First of all, power must be conferred upon appointed representative of the province so as to carry the government of Canada and with the power to call an election as soon as possible after the Constitution has been ratified by the people of each and all the province. And I point out at the people of each and all the province. That was in 1937. As you see there, Alberta has the sovereign right to use its own credit. Yes, it is true. It is in the Constitution of Canada. Of course it can. Yes, it can issue and use its own credit. That's entirely true under the Constitution of Canada. Still is to this day. But we don't have Canada. Remember. The next step for the De Jure Society, the signature of the Act of Union in De Jure Canada, reading and signature onto the Constitution of Canada, which I would like to point now. Where do we go now? This is the title of this section, which is going to end this conference for my part. But where do we go? We've already done that. We've been there. This conference was written in 2019 by Maureen Weir and I. Thank you very much. She wrote it. I was there to make the resume that I just made you and put the bullet point aside with alongside her. Thanks to her. Since then, we've had what Russell Roger Smith just said. We've made a constitutional convention in all its glory. It's all recorded. It's all on my YouTube channel, once again. And yeah, we've done it from each and every province. Very person says, I want Canada. And I want this to be the Constitution of Canada. I want Canada to be a constitutional monarchy, as it says in 1867. So there has been nomination variously of de jure governor general, lieutenant governor for each province, and there was a renewal of the claim of rights, of royal right, for 2 years back then. I won't blow your head about everything that has been done in Falcon Lake, Manitoba. I will just switch to the next slide. And that is up to you to answer this question. I've exposed to you that grand jury can be done, should be done. There's very few things to respect. 23 people, and be a little bit serious about it. You don't drink a 24 keg of beer right before you get there. You present your case, you give a chance to the opposition, and you let the 23 people decide. And you promise nothing to anyone while you do that. I know people want to get paid, and grand jury can be requesting some investment in time, but it's better that than to watch and pay Roger to watch the NHL now that they've sold hockey and we don't have access to our national sport anymore. The government has been judged illegal, illegitimate, unconstitutional by the grand jury of 2015. There's nothing more to say. Where do we go now? You take what I just told you and you use that in everything else. The government's illegal. All the commercial license are illegal. Therefore, yeah, here's a truck, illegal license. Here's a taxi or cab, illegal license. Here's BC Place, illegal license. Here's Roger, illegal license. Here's a grocery store. Yeah, I can go on. Everything that they've done since 1931 has no legal basis. Zero. You can do a grand jury about whatever bullshit you think it's appropriate. That'd be a waste of time. It is up to you to organize your grand jury. You don't decide on your own because, for Jeff said so that now the government's illegal. Ultimately, there's a way to do it alone. You face a government agent. If he's giving you a good service and answering what you need, you don't need to, you don't need to spit on these people. But if they're doing really something that is against every moral, then you can step in alone. But it's not really the way. The way is directly, because the government, it doesn't exist legally, directly make the real government of Canada according to the Constitution and say from now on we got Canada in our own hand. This is Canada. This is BNA Act 1867. It is done like so. Everybody or anybody that doesn't do like so, so long, including you. The person's gonna see that. Nobody can take that. Says, okay, now look, Jeff proven that the government is illegal. We're gonna split Alberta. Fuck you. Not happening. Because that's what they're doing. This is why they've done all this mess. This is why you want to split Alberta. Because now, oh yeah. Same thing for Quebec, by the way. Oh, fuck, Canada's so bad, so bad. Well, people from here fucked it up. They never respected anything in 1867, the BNA Act. Now it's time that we do that because we've never done that. Yes, it's a mess. Yes, it's a piece of shit. Yes, nothing's illegal is legal. We've been hijacked. These are pirates. They're illegitimate. They're illegal. Whatever they say. Yeah, oh, well, they got 31,000 bar association lawyer in Quebec. What do you think? That's first 31,000 trader to whatever Canada is in reality, not the bullshit that we have. And they keep everybody else in line because you're a criminal now, you're gonna go to jail. See, we got the court, we got the jail, we got the cops, and you're going. You're a criminal. What have I done? You didn't pay your dog license tag. Wow. How many days in jail in Quebec for not having your dog's license tag renew on time? Take it back. It's yours. Do grand jury. Do them properly. And be public about it. Be really, really, really public about it. Don't promise anything. Just do it.